Hello and welcome to another edition of Coffee Talk with immigration attorney Brian D. Lerner. In this set of videos we are talking about the L's. Now we're talking some specifics about the 1 year of employment that's required, and over the last video we did go over some specifics, but what about the 1 year preceding admission versus the 1 year preceding petition? Now, the statute and regulations appear to be in some conflict with regard to whether the 1 year requirement must be met prior to seeking admission into the U.S. or prior to filing the I-129 petition. And obviously, if you meet both, this isn't an issue for you, but a lot of times you don't. And so it's necessary to analyze the situation here. For example, in one case, an alien who within 3 years preceding the time of the application for admission into the U.S. has been employed continuously for 1 year. And then there's regulations that show an alien who within 3 years of preceding the time of his or her application for admission into the United States has been abroad continuously for 1 year. So you can see that those two provisions, while similar, say a bit of different things, and the question is, which one do you use? Well, there are letters from immigration, from the chief counsel essentially, that say based on the statutory definition, it's clear it was the intent of Congress to require that the foreign national's qualifying L-1 employment must have occurred within the 3 years period immediately preceding the alien's application for admission into the United States. It does seem to rub against what the Code of Federal Regulations says, but if you fall within one of these situations, you can essentially argue it both ways. But for example, a person who attends postgraduate school in the U.S. for 1 year, let's say in 2004, and an F-1, which is a student visa, and works for the company for 2 years, or had worked for the company for 2 years before in 2001, would qualify if the date of admission was used, because he was admitted in 2004 and within 3 years prior to 2004 had worked for a year continuously. But it would not qualify if the filing of the petition was used after this person, for example, completed their study in 2005, because then you would of course have to look and see if 2002 or later there was 1 year, which there wasn't. So again, you can argue it both ways, but realistically, try to file the L within 1 year or 3 years preceding date of admission and filing the I-21. It will just make it easier. Okay, more on the coming videos.